Let's start with Judge Boseberg. Professor Luther, is it consistent with the judge's oath of office to sign an order for which there is zero basis in law and zero basis in fact?
Absolutely not.
Is it consistent with a judge's oath to do whatever a prosecutor asks him without inquiring as to the facts or the law?
It's completely inconsistent.
Judge Boseberg signed multiple orders. I'm holding one of them in my hand. That's his signature at the bottom. Ordering the phone companies who had been subpoenaed not to disclose to the members of the Senate and the members of the House that their phone records had been subpoenaed. As you noted in your testimony, that order is directly contrary to federal statute. Congress in 2004 made it illegal for a phone company to disclose a senator's phone records without notifying the senator in question. Is there any basis for a judge to disregard unambiguous federal statutory language?
Absolutely not.
Judge Boseberg signed an order that says, quote, "The court finds reasonable grounds to believe that such disclosure," in other words, informing the senators their phone records had been subpoenaed, "will result in the destruction of or tampering with evidence, intimidation of potential witnesses, and serious jeopardy to the investigation." Is there any conceivable basis for Judge Boseberg signing that, particularly given Jack Smith's testimony now that Judge Boseberg had no idea whose phone records he was signing off on?
I've been struggling for the last few weeks to come up with one, but I can't. And I'll mention we wouldn't even know about this if it weren't for Chairman Grassley's oversight efforts.
That is true. And Professor Vladeck, you suggested the remedy for an erroneous decision is appeal. Judge Boseberg signed a secret nondisclosure order that was ex parte with only the Department of Justice in front of him. Is there any conceivable universe in which anyone could appeal that?
So, Senator, as you know, there are circumstances in which the providers can decline to comply. Indeed, I believe in one of the cases, Verizon actually said it was not going to comply with the NDO. I believe that's part of the record as well. And those orders are themselves also subject to challenge in court. Now, Senator, you and I have had this conversation for a long time about how there are lots of gaps in federal law when it comes to the targets of surveillance not being able to object.
Did the targets of surveillance know about this?
No, but I would also remind—
Could the senators whose records were subpoenaed, contrary to federal law, appeal it?
So, no, but of course, Judge Boseberg didn't know, first, that these were senators, second, that their
nor did
communications were covered
Professor
by
Vladeck, nor did he inquire. And in fact, I'm going to go back to Professor Luther's statement, because in an ordinary circumstance, a judge entering an order that he doesn't know who it's applying to, he doesn't know any facts, he doesn't know anything, on the ordinary basis, you'd say, yeah, there's zero basis in fact, but there is actually an explanation for why he did so.
Let's start with Judge Boseberg, because what you're about to hear isn't politics as usual. It's a collision between law, power, and silence. One question sets the tone. Is it consistent with a judge's oath of office? Is it consistent with a judge's oath of office to sign an order with zero basis in law and zero basis in fact? The answer? Absolutely not. Multiple orders, a real signature at the bottom. Judge Boseberg ordered phone companies already subpoenaed to stay silent about one crucial detail. They were forbidden from telling members of the United States Senate that their phone records had been taken. Here's the problem. Federal law says the exact opposite. In 2004, Congress made it illegal for a phone company to hand over a senator's records without notifying that senator. Clear, unambiguous, black-letter law. Is there any basis for a judge to disregard federal statute? Absolutely not. Yet the order claims something extraordinary, that notifying senators would lead to destruction of evidence, witness intimidation, serious jeopardy to the investigation. So here's the obvious question. Is there any conceivable basis for signing an order like that? Especially when the prosecutor later admitted the judge didn't even know whose phone records were involved. I've struggled for weeks to come up with one. I can't. And there's more. This wasn't public. This wasn't contested. This was a secret non-disclosure order, issued ex parte with only the Department of Justice in the room. No targets notified, no senators informed, no appeal possible. Think about that. How do you appeal an order you don't know exists? How do you challenge surveillance you're never told happened? Did the targets of surveillance know? No. Could the senators appeal? No, because they were never told. We're told the judge didn't know they were senators, didn't know the facts, didn't inquire. So why sign? According to the argument laid out, Judge Boseberg knew one thing: that the prosecutor was Jack Smith, that the investigation targeted Republicans, hundreds of them, connected to Donald Trump.
Because Judge Boseberg did know one thing. He knew that Jack Smith was a partisan Democrat engaged in an effort to go after Donald Trump, that he was subpoenaing over 400 Republicans. So the one thing he knew is all of these targets were Republicans. So the only conceivable basis for Judge Boseberg signing these orders one after the other is an animus that says every Republican on planet Earth, every American who voted for Donald Trump, there is reasonable basis to believe they are criminals.
Senator,
I'm done with your question.
I'm sorry.
There is no other basis for his signing that order. He knew that. He knew Jack Smith. Welcome to the fast food counter at McDonald's. Whatever you want, all the fries you want, I will sign, ordered. That is perfectly fine if you are the chairman of the DNC. Being a partisan hack, or for that matter, the chairman of the RNC, either side can be partisan hacks. Judges are expected not to be. And I would point out this is a pattern we've seen before for 4 years during the Biden DOJ. We saw the Department of Justice refuse to enforce the law when violent protesters were outside the homes of Supreme Court justices. It was directly contrary to 18 U.S.C. Section 1507. It was a felony on national television being committed over and over again, and Merrick Garland, a rogue partisan attorney general, refused to enforce the law. Why? Because he supported the objectives of the protesters. That kind of hypocrisy, let me be clear, I would object to an order that found Democrat members of the Senate, absent real and meaningful evidence, were likely to be criminals. That's what Judge Boseberg signed off on.
Judges aren't supposed to be partisan hacks, not blue, not red, neutral. And critics say this wasn't an isolated moment. For years, laws went unenforced, statutes ignored, felonies committed on national television outside Supreme Court justices' homes. The law was clear. The response was silence. Why? Because enforcement didn't align with political objectives. Here's the line that matters. This isn't about party. This isn't about left or right. If a judge had signed an order branding Democratic senators as criminals without real evidence, there would be outrage. And rightly so. The law doesn't survive when judges stop asking questions. And secrecy isn't justice. If transparency matters, share this. If the rule of law matters, subscribe. Because silence only helps the next signature.